Hello everyone, and welcome. As a seasoned crime analyst and storyteller, I'm here to unravel the complex details of true crime cases and present them in a way that's both engaging and easy to understand. Today, we're diving deep into the latest developments in the Idaho case, specifically the pretrial hearing for Bryan Kohberger that took place on May 15, 2025. Many of us followed the live stream, but for those who couldn't dedicate 3 hours to it, I've distilled the key takeaways into a concise summary. Now, before we jump into the summary of the hearing itself, something significant happened towards the end that left many of us speculating. Was the judge's stern demeanor and subsequent order related to the recent Dateline episode? Dateline had aired its third installment on the Idaho case on May 9, 2025, revealing what seemed to be new, previously uncirculated evidence. This included surveillance footage and alleged Google and Amazon searches by Bryan Kohberger. This raised questions about the source of this information, particularly given the existing gag order in the case. The gag order, for those unfamiliar, prohibits individuals involved from making public comments to the media. So, the release of such specific details in a national broadcast naturally sparked concerns. I even discussed this with attorney Josh Ritter, wondering if these revelations constituted a violation. Following that pretrial hearing, we now have official documents that confirm our suspicions about the Dateline episode. But first, let's revisit the clip from the hearing that initially caught everyone's attention. The judge stated, "In the closed session this morning, I indicated to you I am going to be entering an order requiring the retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel, and as I indicated, I would be open to a request for an appointment of a special prosecutor, and that special prosecutor to ask for magistrate inquiry, so they have the power of subpoena and the power to question witnesses under oath as well as the power to grant immunity. So I will be looking for that from you, and that one just deals with the state. I will get you one that deals with your assignment to preserve records." All right, anything else? Judge Hippler was visibly displeased, even angry, in the courtroom. He spoke about the possibility of appointing a special prosecutor, someone to investigate and potentially charge those responsible for these leaks. This immediately raised red flags for many of us, leading us to wonder, did someone violate the non-dissemination order? And was this, in fact, about the Dateline episode? The answer, unequivocally, is yes. The documents released after the pretrial hearing, titled Document and Records Hold Order, clearly state, based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case and the defendant Bryan Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury, and will likely substantially increase the cost to be borne by taxpayers of Latah County to prosecute this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Accordingly, the court finds it is imperative to attempt to see that the source of such leak is identified and held to account. So, it's abundantly clear that someone is facing serious consequences. This document also highlights the crucial impact such leaks have on the integrity of the judicial process, particularly the ability to seat an impartial jury. The court emphasizes that identifying and holding the source accountable is the best way to deter future violations. The order further stipulates that all persons who at any time past or present worked directly or indirectly by employment contract, consultation, or otherwise for or on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons for the murders that are the subject of the instant case are hereby prohibited from deleting, discarding, overwriting, destroying, altering, or otherwise making unavailable any, whether electronic or in material form, records, files, documents, metadata, messages, emails, text messages, direct or private messages, phone logs or logs of communication, regardless of whether made or kept on a work-owned or personal account device or messaging app that in any way relate to or document the fact or substance of communications with third persons, including representatives of the media or other persons or entities outside of law enforcement, which communications in any way relate to, referred to, or concern the investigation of Bryan Kohberger, the facts or allegations uncovered or reported to law enforcement concerning Bryan Kohberger, or the investigation into the homicides that are the subject of the current or then potential criminal prosecution of Bryan Kohberger, collectively documents or singularly a document. All such documents or materials or records could potentially constitute a document, even if it is uncertain whether such meet that criteria, shall be preserved and must be protected from deletion, alteration, or loss until further order of the court. Any feature on any device or account that is set to automatically delete or overwrite information that could be covered by this order must immediately be disabled. Furthermore, within 7 days, initially 14 but then scratched out and changed to 7, the state shall submit to the court in camera a list of all individuals within law enforcement and prosecuting agencies, past or present, who are known to have had access to any facts related to the investigation of the defendant, including but not limited to surveillance videos of suspect vehicle 1, the ATT records for the defendant's cell phone and the content of the defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and information associated with the defendant's Amazon account or any information referenced in the above-mentioned Dateline episode regarding this case. The state is further required to provide a copy of this order to all such individuals and document that it has done so. Failure to comply with this order may be a basis for a finding of contempt of court and such other civil and criminal consequences as may be appropriate. Within 7 days, the state must also provide to the court a written plan designed to address and prevent the future unauthorized disclosure of information related to this case and what it has done or proposes to do to identify any violations of the court's non-dissemination orders previously entered in this case and those responsible for such violations. This is a powerful order, and it's clear the court is taking these leaks very seriously. While some of the information revealed in the Dateline episode, such as details about Bryan Kohberger's character, may not be admissible at trial, crucial elements like the surveillance footage and the Amazon searches could prove highly significant. The mention of internet searches for a K-bar knife, for instance, could be a treasure trove of information for the police. The judge also indicated that a similar document and records hold order would be issued for the defense. There was also a sealed portion of the pretrial hearing. A separate order explained the purpose of this sealed hearing on May 15, 2025, to inform the parties about the orders to maintain records and to determine if a sealed hearing was needed at the end of the open hearing to discuss jury selection questions. So, that clarifies the reason for the closed session. Now, for those who missed the pretrial hearing or just want the key points, let's quickly recap what transpired. If you're new to this case, please check the description box for a background summary and a playlist of our previous deep dives. This case, tragically, involves the murders of Ethan Chapin, Madison Mogen, Kaylee Goncalves, and Xana Kernodle in Moscow, Idaho, on November 13, 2022. Bryan Kohberger was arrested on December 30, 2022 in Pennsylvania, then extradited to Moscow, Idaho. With a change of venue, the trial will now take place in Ada County, Boise, Idaho. First, let's talk about the jury selection process. Judge Hippler laid out a detailed plan with selection commencing on July 30, 2025. This process will not be live-streamed, but will be broadcast to a separate courtroom for public viewing. Juror questionnaires will remain confidential, shared via a secure drive, and attorneys can request to be present during their completion. Jurors will be assigned random numbers and their identities will be protected. No names or faces will be broadcast. The court aims to process 3 to 4 panels daily, with a goal of having 50 to 55 jurors passing for cause, followed by peremptory challenges, 12 per side. They plan to select 20 jurors in total, including 8 alternates, which makes sense given the gravity and length of this death penalty case. Regarding the trial schedule, opening statements are set to begin on August 11, 2025, and the trial is currently scheduled to run until November 7. This is a significant duration, approximately 87 nights from the start of opening statements to the scheduled completion date. The trial will run Monday through Friday, from 8:45 a.m. to 3:30 p.m., with potential extensions if the jury is sequestered. The judge doesn't initially plan to sequester the jury during Phase 1 of the trial. However, if Bryan Kohberger is found guilty and the trial moves to Phase 2, the punishment or penalty phase, the jury will be sequestered and trial hours will be extended. There will be no trial on holidays, specifically September 1st and October 13th. November 11th was also mentioned, though it falls after the current scheduled end date. The judge emphasized minimizing surprises by addressing evidentiary issues before trial sessions, which will be held from 8:15 a.m. to 8:45 a.m. and 3:45 p.m. to 4:30 p.m. daily. Technology needs for presentations must be tested in advance, with the court providing only basic tools. As for courtroom procedures, witnesses must be notified by 5:00 p.m. daily, noon on Saturdays if the jury is requested to work weekends, with a tiered list of those definitely and potentially called, along with associated exhibits. Rule 615 will exclude witnesses from the courtroom, with exceptions for experts, investigators, victims, and designated representatives. Experts may even watch live stream testimony remotely if agreed upon. Exhibits require advance notice and authenticity agreements to streamline admission. Physical objects, such as potential knives, though likely replicas as there has been no official mention of the actual murder weapon being found, will be secured, and voluminous documents should be segmented for clarity. Opening statements and closings must avoid argument, with time limits set based on reasonable estimates, and exhibits used in openings need prior agreement. Objections should be concise, for example, objection, hearsay, without argument unless a sidebar is requested. Anticipated objections should be discussed pre-trial. The judge appears to be meticulously planning to prevent any unnecessary drama or delays in the courtroom. For seating and broadcasting, reserved seating is allocated for victims' and defendants' families, with 2 seats specifically for the surviving roommates and the burglary victims. Unused seats must be reported weekly to allow public access on a first-come, first-served basis. The trial will be live-streamed via a court-controlled feed, with no external media showing static views of counsel tables, the podium, the witness stand, and the bench. No close-ups will be permitted. Victims and certain witnesses, such as covert law enforcement, may request audio-only testimony to protect their identities, subject to court approval and balancing public interest. Regarding evidence and motions, the defense's alternate perpetrator proffer is currently sealed, with a deadline of May 23, 2025, to provide supporting evidence and admissibility arguments. The state will respond by June 6, with a hearing set for June 18, which will very likely be a closed or sealed hearing. This means we may not hear details about the alternate perpetrator until trial, if the judge allows that information to be presented. A model of the crime scene, not to scale, is available for inspection and will be stored outside the courtroom when not in use. The court addressed DNA terminology, allowing clarifying instructions if needed, and approved a stipulated instruction on the IgG tip. For jury instructions and the penalty phase, preliminary jury instructions will be sent soon, combining capital case instructions for clarity. Parties can propose additional instructions. If a guilty verdict is reached, the penalty phase will begin promptly the next day or on Monday if a verdict is reached on a Friday, with sequestration and extended hours. The defense must submit a last best offer declaration by June or early July for post-conviction records. Finally, courtroom conduct was also addressed. The judge stressed professionalism, prohibiting direct counsel communication in court. Lawyers must refer to each other professionally, for example, Ms. Taylor or Mr. Thompson, not by first name while on the record, and avoid making unfounded accusations. Contact with jurors is strictly forbidden, with immediate reporting required for any incidental encounters. The judge even humorously instructed counsel that if they see a juror in a public place, they should run in the opposite direction. Non-dissemination orders require record retention by both sides, and as we discussed, there's a potential appointment of a special prosecutor for violations. Daily or real-time transcripts are available for a fee with advanced coordination. The court may reconsider sequestration based on media activity, with potential juror hardship addressed in questionnaires. The state can retrieve grand jury exhibits, ensuring proper documentation to preserve the record. This summary truly gives us a much clearer picture of what transpired at the pretrial hearing. We now have significantly more information about the case's trajectory. I can only imagine the prosecution and perhaps even the defense are reeling from the recent information that has become public. There's a status conference or hearing coming up, and I can't imagine this topic won't be a significant point of discussion for the judge. I'll certainly keep you updated on what happens next. It remains to be seen if they'll identify who leaked this information to Dateline, and if that individual will be publicly named. We'll have to wait and see. As always, I'm keeping a close eye on this case, and I'll keep you posted on every development. From this summary, you have the next court dates, when jury selection starts, and when the trial is set to begin. It truly seems to be on track to commence with opening statements on August 11th. I say on track because, as we've seen in so many cases, trials often get postponed. This one has already faced a few delays, but Judge Hippler seems determined to keep it moving forward. We're already almost 3 years out from the tragic events, so I'm sure the families involved are quite relieved that things are progressing relatively smoothly. Thank you so much for watching, and I'll see you in the next one. In the meantime, stay safe. Please like and subscribe to the channel to be the first to receive notifications every time a new video is released. Thank you. Good luck.